On January 11, 2026, in a Texas state courtroom, Judge West presided over a motion to revoke probation for defendant Delvin Jones. Jones had been placed on probation in September 2020 for credit or debit card abuse, a state jail felony, but now faced revocation after allegedly committing a new theft offense in April 2024. The case highlights the critical decision points in probation revocation proceedings, where defendants must choose between contesting allegations and negotiating agreements that could keep them out of prison.
That's it. Thank you, Your Honor.
Thank you. Good luck.
Maybe excuse me.
Yes, thank you, sir. Let's see, Mr. Parker on Delvin Jones. Mr. Smith.
Ms. Smith standing in for Tommy.
Good morning, sir. Are you Delvin Jones?
Yes.
And Mr. Parker, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 19-33420, I have a motion to revoke your community supervision. Shows that you were placed on probation September 28th of 2020 for the state jail felony offense of credit or debit card abuse. That was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes.
This motion alleges that you violated your probation. In count 1, it alleges that you committed the new offense of theft of property April 17th of 2024 in Llano County, Texas. And is that true or not true?
It's true.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes.
And because you actually did what they listed in there?
Yes.
The defendant waived the formal reading of the motion to revoke probation and entered a plea of true to the alleged violation that he committed a new theft offense while on probation for credit card abuse. Under Article 42A.751 of the Texas Code of Criminal Procedure, a court may revoke probation if the defendant violates any condition of community supervision, including the standard condition prohibiting commission of new offenses. The 1994 case of Ex parte Montgomery established that defendants in revocation proceedings may admit to alleged violations through a plea of true rather than guilty, distinguishing these proceedings from original criminal prosecutions. Texas courts require that such admissions be knowing, intelligent, and voluntary, with the defendant understanding he waives his right to contest the allegations at a full hearing. Jones admitted the truth of the allegation that he committed theft in April 2024, satisfying the procedural requirement for a valid admission. By pleading true rather than proceeding to a contested hearing, he avoided the state's burden of proving the violation by a preponderance of the evidence, an easier standard than beyond reasonable doubt, but still requiring credible evidence. The judge's careful questioning about whether Jones acted freely and voluntarily, and because you actually did what they listed, ensures the admission meets constitutional standards for voluntariness under Boykin v. Alabama, 1969. Probation revocation hearings represent a critical juncture where defendants trade due process protections for leniency. Courts must vigilantly protect against coerced admissions as the consequences, potential imprisonment, are severe. This procedural safeguard ensures that defendants who maintain innocence can force the state to prove its case, while those who admit violations do so with full awareness of their rights.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for me to continue your probation, extend
Extended 2 years, and at the bottom it says run concurrently with the probation in Llano County.
I guess, I mean, to say it runs concurrent doesn't really mean
Well,
it.
I understand. I mean,
Because if he gets off of that one early, it doesn't
Right.
mean he gets off
Right.
of this one
I understand,
early.
Judge.
So so the understanding is to extend it for 2 years,
Right.
pretty much.
Right.
I just don't want that to make some
I understand.
agreement later
Right.
that we don't want to be bound by. So I'm going to mark through that runs
Okay.
concurrently
No
with
problem.
it.
Yeah.
And I see probation is here. Thank you, ma'am. And is that what you would suggest as well?
Yes, ma'am.
Okay, thank you.
The judge reviewed the plea agreement with the defendant, identified an ambiguous provision about concurrent probation running with another county's supervision, and proactively struck the language to prevent future disputes. Under Texas Code of Criminal Procedure, Article 42A.751 F, when a court continues probation rather than revoking it, the court may extend the supervision period up to the maximum allowable term. The doctrine of judicial estoppel, articulated in the 2002 Texas Supreme Court case of Whirlpool Corp v. Camacho. prevents parties from taking inconsistent positions in legal proceedings, but courts also have inherent authority to clarify ambiguous agreements before accepting them. Texas courts have consistently held that plea agreements must be definite and certain in all material terms to be enforceable, as established in Ex parte Williams, 1997. Judge West identified a potentially problematic clause suggesting that completing one probation would affect the other, which could create confusion about Jones's obligations. By marking through the concurrent language and confirming the core agreement, 2 additional years of probation, the judge ensured the parties had a clear, enforceable understanding. This judicial intervention protects both the defendant from unintended consequences and the state from future litigation over the agreement's meaning. Ambiguous plea agreements breed litigation, undermine finality, and can result in defendants serving longer than anticipated or violating conditions they didn't understand. Judicial vigilance at the acceptance stage prevents these problems and exemplifies how courts serve as gatekeepers of fair process, even in negotiated resolutions.
All right, then. All right, Mr. Jones, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation. However, I'm not going to do that. I'm going to give you this opportunity to remain on probation. I'm going to extend your probation for 2 years. Obviously, you're ordered to follow all of the rules and conditions of probation, especially your order not to be arrested or charged or convicted of anything else. Not anything, but the fact that you picked up a theft after a credit debit card abuse gives me some concern because it's the same type of behavior. So this is a great opportunity. You will not get it again. Do you understand? You understand?
Yes.
All right.
He's on probation. He's in the Austin area, and I think they're aware of that. So,
All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you've waived any right to appeal. And then if probation needs to talk to you before you leave, just make sure you talk to your probation officer. Hang on just a second. I'm waiting on something.
yeah, okay. Not yet. Wait.
Stop and talk to probation right over there on your way out, please. Thank you. Huh?
It's an ADMITS building in my block. When you walk off, taking left, all the way down, you let me,
Sorry, they're not in order. That's how they sent them to me. For what? Well, yeah, I mean, why wouldn't you if you didn't just wear it and it's very.
Would you like me to file a formal motion?
Yeah. Mr.
Judge West formally accepted Delvin Jones's plea of true, found sufficient evidence existed to revoke his probation, but elected to continue supervision with a 2-year extension. Jones avoided imprisonment for his violation, but received an explicit warning that this leniency would not be repeated. The court's decision reflects the discretionary authority trial judges possess in probation matters, finding violations proven yet choosing rehabilitation over incarceration. This proceeding illustrates the fundamental tension in criminal justice between punishment and rehabilitation. Texas law grants judges extraordinary discretion in probation revocation. They may find violations proven yet still decline to revoke, extending supervision instead. This flexibility serves multiple purposes. It reduces prison populations, acknowledges that relapse is common, and allows defendants to demonstrate rehabilitation without the devastating interruption of incarceration. However, this discretion operates within constitutional boundaries. The Supreme Court's decision in Morrissey v. Brewer, 1972, established that probationers have a liberty interest entitling them to due process before revocation, including written notice, disclosure of evidence, opportunity to be heard, and a neutral decision-maker. Yet the court in Gagnon v. Scarpelli, 1973, clarified that these protections need not include appointed counsel in all cases, leaving indigent defendants to navigate complex proceedings alone, unless fundamental fairness requires representation. The second chance Jones received embodies a pragmatic recognition that technical compliance with probation conditions often proves impossible for defendants struggling with poverty, addiction, or mental health challenges. Yet the judge's stern warning, "You will not get it again," also reflects the reality that judicial patience has limits. Repeat violations typically result in revocation, as courts balance individual circumstances against community safety and the integrity of the sentencing system. For viewers, this case demonstrates that criminal procedure involves countless discretionary decisions shaping outcomes as much as guilt or innocence. Understanding these procedural inflection points where rights can be waived, agreements negotiated, and mercy exercised provides essential context for evaluating how justice actually functions in American courts. If you found this analysis valuable, subscribe for more educational court content breaking down real legal proceedings. Share this video with anyone interested in criminal justice and comment below with questions about probation law or suggestions for future cases to examine.